The questions asked by most plaintiff attorneys who are confronted with an ERISA plan's reimbursement demand are, where is the fairness, where is the equity? After the recent U.S. Supreme Court decision in U.S. Airways versus McCutcheon, the answer to either question is hard to find. In McCutcheon, the Supreme Court reasoned that questions of equity and fairness were beside the point. The question of equity and fairness in liens comes from two recognizable equitable concepts. The first is the make whole doctrine, sometimes called the full compensation rule, which is the principle that the injured party should be fully compensated for their injuries or made whole before any subrogating party is paid. The second is the common fund doctrine, which states that anyone who wishes to benefit from the common fund created by resolution of the personal injury claim should help pay the costs for the creation of that fund. Simply put, the subrogating party should pay their fair share of attorney fees and litigation costs. Both of these doctrines are deeply embedded in American jurisprudence, and the application of each in regards to the subrogation rights of an ERISA plan were discussed this year by the U.S. Supreme Court in the McCutcheon case. The court reasoned that both doctrines are important, but both can be overcome by clear and express plan language. The standard of what language is sufficient to overcome these equitable principles varies from federal circuit to federal circuit. However, in general terms, in order to overcome made whole, the plan language must establish a first priority right to the settlement funds and clearly state that the plan expects full repayment of all benefits advanced. To overcome the equitable principle of common fund, the plan language must be exceedingly clear, and in our opinion, it must specifically state that it abrogates common fund. Not using that exact term may mean the language is insufficient to overcome application of this principle. In the McCutcheon case, the court went to great lengths in stating that federal courts should be very reluctant to allow plan language to overcome common fund, and if the language can be read in another way, it should be. The only answer to where is the fairness is that it must be found in a knowledgeable advocate. The McCutcheon court may say fairness is beside the point, but at Synergy we make it the only point. Despite McCutcheon, we still find ways to secure deep reductions on ERISA liens and continue to fight for the injured.